Hi, let's take a look at the legal test of determination regarding fixtures. Understanding the concept of personal versus real property expands to the definition of a fixture. Okay. Fixtures. Items can start out as personal property and then be converted to real property once installed. For example, a chandelier is personal property while it is still in the box, straight from the store. But as soon as it is installed, it becomes real property. The chandelier, once installed, is now a fixture of the real property. A fixture is an item that was once personal property, but is now legally considered to be real property. Fixtures become real property through attachment and return to personal property through severance. If the chandelier is removed, it once again becomes personal property. However, a seller may be obligated to leave a fixture installed with the transfer of property, depending upon the terms of the agreement. Fixtures include attached lights, toilets, sinks, etc. Contracts are generally written to include fixtures as part of real property transferring ownership. To avoid confusion as to whether something is a fixture, standard contracts include predetermined statements about appliances, water softeners, drapes, etc. Otherwise, licensees need to be careful to include clear statements within the contract. Sometimes parties do dispute whether something was supposed to be part of the real estate sale as a fixture. If the matter ends up in court, the judges uses four legal tests to determine whether the item in question is personal property or has become part of the real estate. Legal test of determination. A judge uses four legal tests to determine whether an item in question is personal property or has become part of the real estate. Intent of the parties, method or degree of attachment, agreement and or relationship of the parties, and adaptation of the item. Intent of the parties. The test of intent of the parties examines whether the item was installed with the intent that it would be permanently part of the real estate. An example of this type of test would be a tenant who brings in a washer and dryer. Upon the termination of the lease, the tenant begins to remove the washer and dryer. The landlord interrupts the process, telling the tenant that since the washer and dryer are attached to the property's gas and water lines, it is now part of the real estate and belongs to the landlord. If taken to court, the washer and dryer, even though partially installed, may likely be viewed as personal property by a judge. if the tenant can show that the intent of the tenant was to install the washer and dryer temporarily for the convenience of the tenant. Method or degree of attachment. The test of method or degree of attachment examines whether the object can be detached without leaving substantial damage. If the property is left damaged, then removing it has actually hurt the value of the property more than had the item never been attached. The process also examines the process utilized to attach the item, such as screws, glues, etc., and to what extent the installation altered the property. If, for example, when a tenant installed a washer and dryer, the real estate property had to be altered to allow room for the vents and the gas lines and water lines because there was never a washer and dryer there when the tenant moved in, it now becomes less clear that it belongs to the tenant. Agreement and or relationship of the parties. This test of agreement and or relationship of the parties examines who's who in the relationship, landlord versus tenant, buyer versus seller, and who is making what claim. The judge will compare the claims being made by the parties to the terms of the rental or purchase agreements. The tendency of the courts when ownership is unclear is to give the benefit of the doubt to buyers and tenants. In the example of the tenant removing the washer and dryer, the judge would examine the lease agreement closely to see if the tenant had permission to alter the property in order to install the washer and dryer. If the lease agreement fails to cover the issue, the judge is likely to weigh in the tenant's favor, assuming that as a tenant, the motivation was to benefit the tenant and not the property. Adaptation of the item. The test of adaptation of the item examines whether the item in question has become an integral part of the home or building. If it has, then it will be declared as a fixture and part of the real estate. This is likely when an item has been designed for the space or installed permanently. Examples include a built-in stereo system, hot water solar heating pipes, wall-to-wall carpet that has been cut to the dimensions of the property, or attic insulation. In the example of the tenant removing the washer and dryer, because the washer and dryer is probably of standard size, easily replaced with any brand of washer and dryer, the tenant likely can show that the value of the property was actually increased by the ease of another tenant installing their own washer and dryer. Legal test of determination summarized. You have intent of the parties, method or degree of attachment, agreement and or relationship of the parties, and adaptation of the item. Fixtures. Listing and sales contracts should clearly specify which items are considered real property in the transaction and any personal property that is to be included. Although an item may be personal property, it can be designated as staying per the terms of the contract. Property and vacation areas are often sold furnished or turnkey furnished. Turnkey furnished means that all the items remain, such as pots, pans, and towels, in addition to the furniture. In the agreement, fixtures can be excluded from the sale. However, if a seller wants to exclude an item, it is better to advise the seller to have the item removed before marketing the property. Buyers tend to want what they are not supposed to have. Also, don't be confused by what is listed as staying in a listing contract or even an advertised listing contract. What rules legally is what is included in the actual purchase agreement contract. A purchase contract signed by a seller and buyer will overrule the listing description. This is where I'll confess a mistake that I once made. Back in Indiana, I made a mistake while acting as a real estate listing agent representing the sellers. When I took the listing, the sellers expressed that they were taking their water softener with them upon the sale of the home. It happened to be a high-priced brand. Because water in that area was very hard, a very good water softener was truly coveted. When I entered the property into the multi-listing service, I did exclude the water softener from the listing description. However, the fill-in-the-blank purchase and sale contract filled out by another agent on behalf of the buyers automatically included the water softeners as transferring with the property. The buyer's agent did not exclude the water softener by writing the exclusion as an extra statement, and I did not catch it. If I had, I would have countered that one point. Well, my sellers moved out and took the water softener with them and installed it into their new home. The day of closing, the buyers walked through the property to make sure it was acceptable before signing final ownership papers. They noticed that the water softener had been removed and requested that it be returned. Realizing that the mistake was actually mine, I didn't prompt my sellers to return the softener. Instead, I negotiated to personally pay to replace the softener with the unit from the local hardware store. After that mistake, I had a strict policy never to exclude anything that would be considered as a normal part of the transaction. If a seller wanted to do so, I insisted that the item be removed before the property went on the market. That was a mistake that I wasn't about to repeat.